Section 240, ladder fall, lawsuit, New York, Scaffold Law rights. Attorney Andrew M. Stengel. You climb a ladder every day on a New York construction site. One bad moment can change a life. Falls from ladders are among the most common and most serious accidents on New York job sites. Those injuries can keep someone out of work for years. However, New York's labor law shields construction workers in a way few other states do. A Section 240 ladder fall lawsuit, also called a scaffold law lawsuit, gives an injured worker powerful rights. An injured worker can recover from the property owner and general contractor on an absolute liability basis. That right kicks in when a fall happens because the ladder had defects, sat in the wrong spot, or lacked required safety devices. This post walks through when Section 240 applies and how the recalcitrant worker defense plays out. It also covers what evidence matters and what kinds of injuries drive these lawsuits. Most importantly, it shows why moving fast matters. When Section 240 covers a New York ladder fall, Section 240(1) reaches a specific set of failures on a job site. First, the statute covers ladder falls when the ladder itself is defective. That includes cracked, bent, or missing rungs or a frame that failed under load. Next, it covers falls when someone places the ladder incorrectly. Leaning at a bad angle, sitting on an unstable surface, or never tied off at the top all qualify. Furthermore, the law applies when the ladder was simply too short for the work and the worker had to overreach. Finally, Section 240 covers falls that happen when no one provides the required fall protection equipment like harnesses, lifelines, or anchor points. When any of those conditions contributed to a fall on a New York construction site, the result is absolute liability. Both the owner and the general contractor face liability. As a rule, comparative negligence does not reduce the recovery. Worker conduct cannot block the lawsuit unless a narrow defense applies. The recalcitrant worker defense and how New York courts handle it. Property owners and general contractors do not give up easily. In Section 240 cases, they often raise the recalcitrant worker defense. Their argument goes that the worker refused to use the safety equipment the supervisor provided, so the owner should not pay. To win that defense, the property owner or contractor has to prove three specific things. First, someone gave the worker a direct, specific instruction to use a particular safety device. Next, that device was immediately available on the job site. Finally, the worker refused without a legitimate reason. In practice, this is a narrow defense in New York. Generic safety meetings, written policies, and one-time orientations rarely satisfy the standard. Courts demand concrete proof of a specific instruction tied to the specific work that caused the fall. Therefore, an experienced New York labor law attorney can usually challenge each element and keep the lawsuit on track. Documenting the fall. Evidence that wins New York, Section 240 cases. Strong New York Section 240 cases come from fast, careful documentation. The ladder itself is the most important piece of physical evidence. Its condition, length, and the presence or absence of safety features all matter. OSHA reports also matter. Federal investigators document what happened and what safety standards a contractor failed to follow. Witness statements from co-workers, security footage from the site, and an expert reconstruction of the fall round out the evidentiary picture. Furthermore, time is of the essence. For one, job sites change quickly. Ladders disappear or end up in a dumpster. Witnesses move on. As a result, an attorney brought in early can preserve the ladder, the records, and the witness accounts. Acting fast keeps key evidence from vanishing. Common injuries in New York construction, ladder falls. Ladder falls hit very hard. The most common injuries include traumatic brain injuries, spinal cord injuries, multiple fractures, and shoulder injuries. Additionally, many of these require surgery and months or years of rehabilitation. Sometimes a ladder fall causes death. For a worker who suffered a serious permanent injury, the difference between workers' compensation alone and a full Section 240 recovery can be enormous. Workers' compensation pays a fraction of lost wages and medical bills, with no recovery for pain and suffering. By contrast, a Section 240 lawsuit can include the full value of past and future lost earnings, all medical care and pain and suffering. Sometimes a spouse can also bring a loss of consortium claim. Such a gap can run into hundreds of thousands or even millions of dollars. Talk to the law firm of Andrew M. Stengel, PC, about your New York ladder fall. Of course, a construction ladder fall does not have to define the rest of your life. New York's Scaffold Law exists for moments like this. Section 240 lawsuits give injured workers a way to turn the law into a real recovery. At the law firm of Andrew M. Stengel, PC, we help construction workers across New York pursue Section 240 ladder fall lawsuits. We pin liability where it belongs. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.